Okay, welcome everyone. Thanks for joining us this afternoon. We are today welcoming Cora Wilson from her Nanaimo office. So hi Cora, thanks for joining us. And we'll be talking about Strata Council electronic meetings and of course hearings and how you're administering that process through your routine council meetings. This session is being recorded and it will be on the website by noon tomorrow. We encourage everyone to share it with their Strata Council members and their fellow owners and to give them a link to that as well. Thanks again to all the CHOA members across BC for your continued support and your membership and your attendance at these sessions as it supports the association in its operation. And thanks to BC Housing and the BC government for all of their continued partnership and support that they have extended out to condominiums and stratas across the province, and it certainly has made a substantial difference. We will monitor and hold all the questions to the end of the session, and we will continue recording at that time. If you do have a question, put it into the Q&A. I will go through and group them into specific target areas, and we'll get going on the session. And please feel free, if you have any questions, to email us at info@choa.bc.ca.
Thank you very much. I just wanted to start by saying we have a COVID-19 order under the Emergency Program Act that permits electronic general meetings, but it does not address hearings expressly, and it doesn't refer to electronic council meetings. I can indicate that electronic council meetings are currently governed in the standard bylaws, and so I'll be reviewing those with you shortly. Next slide. Next slide.
So this is just our
webinar, as Tony indicated, so this is just the privacy indication, and so we just ask when you provide us with your questions, kindly make sure that you don't make reference to the strata plan or any personal information for privacy reasons. In light of that, I'd like to just get into the Standard Bylaw 17. Now this standard bylaw, these are the statutory bylaws that apply to every strata corporation in British Columbia, indicate that council meetings can be held by electronic means. And this sets out the procedure or the format for doing that. And I'll just walk you through it. At the option of council, so it's discretionary, council meetings may be held by electronic means. Now, it doesn't indicate the nature of the electronic means, it just indicates electronic means. So this could be by telephone conferencing, it could be by Skype, it could be Zoom, or some other electronic means. But the task is that everyone has to be able to communicate with each other. And when I refer to everyone, I'm referring to the council members as well as other participants. If a council meeting is held by electronic means, then council members are deemed to be present in person. Now what's interesting is Standard Bylaw 17 doesn't indicate whether other participants are deemed to be present in person. And this is relevant because when we talk about hearings, the applicant needs to be present in person in order to comply with the regulations. So we'll talk about that momentarily and indicate the importance of amending your bylaws to deal with electronic hearings. Owners can attend council meetings as observers in the standard bylaws, and this of course includes electronic meetings. Now what's missing there is there's no reference to tenants or other persons, so it is possible for you to amend your bylaws in order to deal with observers and expand or limit or even prohibit observers. So it's open to the strata corporation to do bylaw amendments that deal with these types of procedures. So the question is, how can we schedule an electronic council meeting? Now what we're dealing with is procedure here. And if you're dealing with procedure for a council meeting, you're looking at standard bylaws 14 to 19 to deal with that procedure. If you want to deal with the substantive provisions that govern council matters, such as the control over council matters, conflicts, eligibility for council, election of council, and membership on council, then you're into the provisions of the Strata Property Act. And that would be sections 25 to 34 of the Act itself. It's important to remember that you can't amend the provisions of the Act, and if a bylaw conflicts with the Act, then it's unenforceable to that extent. There are certain provisions in the Act that permit bylaw amendments, and to that extent, the Strata Corporation is open to making amendments. So procedural matters are in that category, and it is possible to make amendments to the bylaws to address procedure, particularly that, which is the subject matter of this conference today, electronic council meetings as well as hearings. Now, an electronic meeting is no different, just to go back to the last slide, than what a meeting is for a council without electronic means. And so essentially you want to be using the same format. You want to be dealing with observers and their restrictions as well. Now, an electronic council meeting is scheduled, and this is dealing with the time frame. So a council member can call a council meeting by giving 1 week's notice. The notice has to specify the reason for calling the meeting, but it does not have to be in writing, and that's important. It'll set out the agenda, but no need, again, for it to be in writing. Now, it's important to calculate what at least 1 week's notice means for calling that meeting. At least 1 week's notice set out in the standard bylaws means that you can't count the day that you call the meeting, and you can't count the day that it's held. So it, in fact, is 9 days to deal with the time frame under the current standard bylaws. Now, council members are typically called by strata corporations on a monthly basis, and they're pre-scheduled in advance so that everyone can plan for those meetings and deal with them accordingly. Next slide. We need to ensure that we get rid of this mystique surrounding electronic meetings as compared to non-electronic meetings. They're exactly the same in terms of process, procedure, etc. Every council member is entitled to vote on the motions. The results are recorded in the minutes, and then the routine business proceeds in the ordinary course. Observers under the standard bylaws cannot attend portions of meetings that address bylaw contravention hearings, rental hardship exemption applications, or other matters that may interfere with privacy. This is also addressed in section 27 of the Act. The Strata Corporation cannot direct or restrict the council in the exercise of its powers or performance of its duties. And this, of course, relates to certain things when you're dealing with infractions. The council has the authority and the discretion to determine, based on the facts of a particular case, whether the person has contravened a bylaw or a rule, whether a person should be fined, whether a person should be required to pay the reasonable cost to remedy a contravention, and whether an owner should be exempted under the hardship provisions of a bylaw provision. These are all areas that are within the jurisdiction of the council, and these matters cannot be interfered with by the Strata Corporation, even by way of a majority vote. These are off limits to the Strata Corporation. A big question is whether or not we can hold a meeting by email, and this has been a topic of great discussion. I'm pleased to confirm that as long as your bylaws are amended, this is a recommended bylaw at this time. We need to ensure that the bylaws are amended because the vote by email doesn't meet the definition of an electronic meeting. You have to, in an electronic meeting, have persons able to communicate with one another. Obviously, if you're on an email, that cannot happen simultaneously. So it doesn't meet the definition of being in attendance at an electronic meeting. The bylaws should be amended to address a number of things, to address the manner and the procedure for dealing with the vote by email, how many people need to respond to the vote by email, how is it conducted, what is the time frame applicable, how do you know when you have approval of that email vote, is it by majority, under what circumstances should you hold the email vote, is it just exceptional circumstances or at any time at the option of council? We recommend the former. And then how do you take the vote and how is it recorded in the minutes? Again, we recommend that such votes be dealt with in a manner that's consistent with electronic decisions made at electronic meetings. So what is a hearing? A hearing is an opportunity to be heard in person, note, in person on a specific matter by the applicant. A hearing, request for a hearing is governed by section 34.1 of the Strata Property Act, and the regulations define what a hearing means. And so that's the opportunity to be heard in person. So therefore, if you want to have an electronic hearing, you do need to amend the definition in your bylaws to deem the person that's going to be heard before council to be present in person, that's the applicant, and also at electronic hearings at a duly convened council meeting, we know that the standard bylaws already deem that the council members are present in person. So you just need to go further in order to make sure that your bylaw covers electronic hearings as well. And those, the electronic hearing bylaws should also address the procedures, the timing for calling and holding, attendance, who can be there, consent, record keeping, and of course, providing information to the owners once decisions are made. Next slide. So hearings are effective tools, and they're used all of the time to address a number of things, such as grievances, application for alteration approval, accommodation for exemption from bylaws, and any other matter. It has to be for a legitimate purpose related to the bylaws themselves as they relate to a particular applicant. So with respect to complaints to the Civil Resolution Tribunal, we know that a precondition to making the application, unless exempted, is a hearing before council, and that must be done before an applicant who is an owner or tenant has jurisdiction or power to make the application. The Civil Resolution Tribunal can, in appropriate circumstances, waive that requirement, but it really underscores the importance of the hearing process in dealing with due process matters. Next slide. It's important to take a look at the procedure for a hearing. If you look at section 34.1 of the Strata Property Act, it indicates that the following persons, owner or tenant, it doesn't say an occupant, so it's important to look at what the wording of the provision says with respect to who has the ability to apply for a hearing. It's just an owner or tenant. They have to submit a written request, so it's not simply a request like a council meeting being called. It has to be in writing. It must specify the nature of any decision that is requested, and essentially it makes a request for a hearing. The hearing will be held at a duly convened council meeting, and that can also be a duly convened electronic council meeting. So this sets out the scope of a hearing. It's arguable that if the request for a hearing does not make a specific request, or if something is dealt with at a hearing that's not requested, then that is not something that the council needs to hear because it's not in the request for the hearing. So this sets out the scope for the hearing itself. It also sets out the time frame for which a hearing must be held, and the time frame is within 4 weeks after the request. So if a written request is made to the Strata Corporation, then once you've got the deemed expiry on that request, you have to add 4 days if you make it by the request by email or by mail or some other matter other than delivering it in person. Then once that time frame has expired, then the hearing has to be held within 4 weeks after the request. So let's say, for example, the request was made on April 30th, and that's the time frame that the delivery expired. So then you would add on 4 weeks, which is 28 days. You're into May 28th. So the question is, when do you have to hold that hearing? And the statute requires that it be held prior to, on or before the 28th. So on the 27th or before. So that's the time frame within which that hearing has to be held. And if the purpose of the request for the hearing is to seek a decision of the council, then the council has to respond in writing within 1 week of the hearing. Now, this is a very short time frame. If you have to, as a council, respond to the person who requested the hearing, the owner or tenant, and you respond by way of email, then you have to add 4 days to the decision time frame. So that means that you don't have this full 7 days. You've actually got 7 days minus the notice period if you send it out by email or by mail or any other method other than by personal delivery. So extremely important to calculate those time frames and diarize them and make sure you're alive to those dates when you're scheduling and dealing with hearings from a procedural perspective. Next slide. There's a question regarding how do you conduct a council hearing if you are a council member. Now we know that if the hearing is for a person to be heard, then it's important that the council address the matter in an appropriate fashion. You want to act like a judge. This is a quasi-judicial proceeding. So you want to act in a manner that is free from bias and that is objective and appears as though you're not prejudging the matter. This doesn't mean that you're prohibited from asking questions during the hearing. It means that you need to make sure that you ask sufficient number of questions in order to assist with a decision. So there's no obligation on a council, though, to answer all questions that are posed by the owner or tenant. There should be caution exercised when engaging the council during a hearing. The council is not required to answer inappropriate questions. This isn't a forum to grill the council or to address matters with the council outside the scope of the request for a legitimate hearing. So the council may request additional information or ask questions to assist with the decision and enable them to make their decision as any judge would in a quasi-judicial capacity. Next slide. Next slide. So a big question that arises on a regular basis is whether or not the council can place a limitation time-wise on a hearing. And the answer is yes, but the restriction on time should be reasonable. For example, it should depend on the complexity of the subject matter. Is this dealing with a very significant alteration? Is it dealing with the approval of a hardship application? Is it dealing with a hearing to approve a companion pet? What evidence is available? What is the content of the hearing? What's the importance of the matter? Are there any witnesses that need to be heard from? And so it should be reasonable dependent upon the subject matter and the content of the hearing. And this is a discretionary matter that council can address on a case-by-case basis. Next slide. So can a hearing be recorded? This is a question that arises frequently. Unless all parties agree, the Strata Corporation should not have a recording in a hearing format. You should always look at your bylaws to see what the bylaws say. What does the privacy bylaw indicate? Does it permit meetings to be recorded? If in a hearing there is a request for a recording and the bylaws permit it, then the recording should be approved by both the applicant as well as by a majority of council. And thereafter, if the meeting is recorded, then information regarding that recording should be made available to all parties at the hearing, being the applicant and counsel. Again, though, these types of things should not be recorded as a matter of course. However, in rare circumstances, it may be appropriate. Next slide. So how does a member who is on council maintain privacy during an electronic hearing? We've often seen on television when people attend that by electronic means that the dog runs into the room or the family members or children. So there is a concern regarding maintaining privacy during a confidential hearing. The manner in which you should deal with that is to find a secure space in your home where you are assured that you won't be interrupted, have the door closed, and try to do whatever it is that you can to protect the privacy and avoid any interference from outside parties. Once you've had your hearing, then the council will meet and make a decision on the matter. And the question arises, what is the procedure for dealing with that information, that decision? How do you enter it into the minutes? So we know if there is a request for a decision on a matter, then the council has to meet at a duly convened council meeting or electronically by emails if your bylaw permits it, and make a decision. The decision is approved in the ordinary course by a majority of eligible council members, and that decision is recorded in the minutes and disseminated to the owners in the ordinary course. Some people disseminate that information by placing it on a web-based password-protected website, or you can deliver it by email if email is consented to by the owners within the strata corporation, or just to those owners, and by other means for those people that haven't consented in that manner. So the information discussed in the hearing and personal and financial information related to the decision is of course excluded from the minutes. This is extremely private and sensitive information. Those copies should be retained as evidence for the decision as necessary. If there's a vote in favor of granting a hardship application, it may not be necessary to keep that financial information. If there is a decision that the hardship application is not granted, then it may be necessary to keep that evidence in case of a challenge against the decision of council, which will be addressed in another forum. So it's a discretionary issue regarding what to do with such information. And if you're in any doubt, you should seek assistance and direction from legal counsel or from other qualified professionals. So this information, decisions need to be recorded in the minutes of the strata corporation. The strata corporation is a corporate entity, and the only way that decisions can actually be recorded for the institutional memory is if they are in those minutes. Councils come, councils go. So that decision needs to be in writing, needs to be recorded in the minutes, and needs to be provided to the owners so that the owners are aware of that decision. And moreover, if there is a decision of the council after a hearing, a letter should be provided to the person that requested the decision, indicating the nature of that decision. So it's a two-step process there. In light of that, we've now completed the this portion of the presentation, and we'd be happy to address the question and answer period.
So, Cora, we have quite a few questions, which is expected. I'll go through the questions that relate specifically to council meetings first, and then we have a number of other follow-up questions, probably from last week's session on electronic meetings as well, as to how we're dealing with electronic meetings from 2 weeks ago. So the first question is, and you kind of addressed this about going into a space of privacy, but if you have a phone-in meeting how can you verify that there was no one else on the calls, especially if you're dealing with confidential information?
Excellent question. So if you have someone on an electronic meeting, how can you verify who is in attendance? I think that the person in charge of the meeting, the facilitator, the chair, should make sure at all times that there is a specific request at the beginning of the meeting for people to identify themselves that are present at the meeting itself. In addition, the chairperson should set out guidelines and regarding the manner in which these electronic meetings will be addressed from a procedural perspective. And that includes excluding persons who are not qualified to be in attendance at the meeting. So the obligation should be on the chairperson to make sure that those items are addressed in sufficient detail so that the chair is satisfied that only proper persons are in attendance at the electronic meeting and no other persons are in attendance. Now, this does open things up to a certain amount of potential abuse because it's possible people could simply not disclose. So there will be a duty on the person that's asked, is there anyone in attendance, to be straightforward, honest, and truthful, and the chair would be entitled to assume that that is the case.
Thank you. The next question, and there's a few of them all kind of relating to the same thing, and really what it has to do with is the hearing process. And most strata corporations don't have a bylaw that deem for the purpose of a hearing, a person is deemed to be present in person. So until they have that, how is a strata going to accommodate that, beyond, of course, agreeing to accommodate the owner in their consent to participating electronically, which they could voluntarily do, but the strata corporation might not have any options or choices?
Thank you. That's an excellent question. I would like to point out at the outset that the electronic hearing process does place the strata corporation between a rock and a hard place. We're all aware that during COVID-19 there is constraints associated with business as usual, and now we've got a new normal. So the question becomes, if we have a difficulty that's not covered off by the order under the Emergency Program Act to permit electronic hearings, and we don't have an amendment to the legislation, then is there even an ability to have an electronic meeting at this time? The regulation 4.01, requires that the person making the application for the hearing be able to make the presentation in person before council. But the bylaws don't deem that a person who's the applicant is present in person at the council meeting. So you need to amend the bylaws. I would think during these emergency circumstances, given this problematic procedural glitch, that a council that has no other alternative is likely going to proceed with the electronic meeting in any event. And perhaps one of the things that it could do procedurally at the beginning of the meeting is ask for everyone to confirm that the electronic meeting includes the participants present in person and the applicant for the hearing, and ask if there's any objections. If there are any objections or any difficulties procedurally moving forward, because there are some procedural problems, then essentially the council may have no alternative but to decline to use the electronic hearing process. And that would be unfortunate. If they did proceed with the electronic hearing process in any event, then it's likely that this could be the basis for an application to the Civil Resolution Tribunal for a determination regarding whether or not the hearing was actually properly constituted and whether the decision arising out of that hearing is a legitimate outcome. The worst case scenario is that the tribunal could order that the matter was not properly addressed and that the hearing needs to be redone. Now, this is difficult if it's a hardship application, because if the decision is not provided by the council with the time frame, within the time frame afforded in the Act, then the hardship application could be granted. So there are constraints and there are difficulties, So I encourage every single strata corporation that doesn't have electronic general meeting bylaws, doesn't have electronic hearing bylaws, and other related bylaws to amend your bylaws as soon as practically possible. And if you're in this situation, seek legal advice regarding how to proceed.
Yeah, there's every likelihood that when the emergency orders, if and when they are lifted, the exemption for electronic meetings would also be lifted. We don't know yet what the outcome may be, and there may be legislative change on the horizon that will simply amend the ability for strata corporations to conduct meetings electronically, and that would be helpful in light of that. But we may end up with another one of these windows of time where there are no electronic meetings, but you can't meet because of social distancing. And and I think strata councils, the next question I think is really good because it's a 7-member council who've conducted 2 electronic meetings, but they have a council member who's insisting that they have to have meetings in person. But when you really apply the rules for social distancing and screening and your obligations as a strata corporation, and especially if you have a property manager, the moment you're trying to bring your property manager on site for your meetings, all of the conditions of the health regulations and WorkSafe regulations will apply as well. It's very difficult when you follow those regulations, it's very difficult to meet those regulations to be able to conduct meetings in person. The 2-meter rule isn't 2 meters between you and the person next to you, but you're sitting against a wall. It's about ingress and egress of spaces. It's about using common facilities. It's about kitchens and washroom facilities and common rooms. Like, all of these things have to be taken into consideration when people are meeting, and it's the social distancing and the not cross contamination that will ensure our public safety here. So, I think this comes back down to, and correct me if I'm wrong, but it comes back down to this is a majority decision of council. If they want to meet electronically, that's what they're going to do, and there aren't 2 types of meetings. There's 1 meeting. If you're meeting electronically, then everybody can either get in on a Zoom meeting or they can phone in. That's a fully constituted electronic meeting.
Correct.
This was an interesting question with respect to bylaw revisions, as a strata is actually going to adopt a number of electronic meetings, but they decided at the same time that they're going to do this, that they're going to do a significant bylaw revision. And so, the question is obvious, and the answer are obvious. Should they have a separate special general meeting just for that bylaw package? But answer is obvious, yes. Just simply to focus the time on it. But I think they should also contemplate information meetings for their owners and get feedback before they actually send out the notice package. There may be significant changes that they might not be able to amend at the meetings, especially if people are issuing restricted proxies. They may not be allowed to do amendments.
Excellent question. Let me address that. And before I do, if I may, Tony and I have just written the 2020 update to the bylaw guide. It deals with the electronic meetings, hearings, and various other things. It's very comprehensive and actually includes specific bylaws for these meetings, including email votes, voting at electronic hearings. There's a lot of information in there, as well as electronic general meetings. There's several very detailed bylaws in here, together with all the procedural steps to set everything up and proceed with the meeting. Now, the question is, if you have a full consolidated set of bylaws, then how should you procedurally approve those bylaws at a general meeting if it's going to be held electronically? Should we be just dealing with specific items, or should we deal with all of them? Well, clearly it's a significant order to deal with a major consolidated bylaw amendment at an electronic general meeting. So how can you mitigate against that tall order? And the answer is, and this is without fail, I think every strata corporation going through such a process should have a town hall electronic meeting or an information meeting to review these bylaws with the owners and make a determination regarding which bylaws are controversial bylaws and which bylaws are not, And then when it comes time to hold the electronic general meeting, if you choose to do that and proceed forward, then essentially you should vote on the controversial bylaws separately at that meeting, and the non-controversial bylaws would form a separate vote. That way you can divide and conquer, and as opposed to having the whole meeting fail because of one controversial pet bylaw, for example, you would be able to get approval of your consolidated set in a much easier fashion. Now there's another option, and Tony alluded to it, and that is you could simply decide which bylaws at this electronic general meeting are the most significant bylaws for your strata corporation at this time, in order to make the whole package more palatable and to ease the time and complexity of your electronic general meeting. For example, you could simply present for approval electronic general meetings, bylaw amendments for that, bylaw amendments for email voting, and bylaw amendments for electronic hearings, and just deal with those items and make your meeting smaller, shorter, more palatable, and then use your restricted proxy or proxy vote or whatever procedures and methods that you set up for your electronic meeting.
That's super. So here's a great question too, because strata corporations have amended their bylaws to permit different types of persons to attend meetings. But the question is, what if a bylaw specifically states owners may not attend a council meeting except by invitation or request only? Is this legal?
So the question relates to what extent is the council able to control council proceedings? And the question relates to the scope of ability to restrict observers. Now, it's possible, because it's not governed in the provisions of the Strata Property Act, to amend bylaws to prohibit observers. And that's within the realm of the owners to make that choice. They would have to approve that bylaw amendment to the standard bylaws by 3/4 vote at a general meeting. And of course, it'd have to be filed. Right now, observers can be present at a council meeting under the standard bylaws, but it only refers to owners in the standard bylaws. It doesn't refer to tenants or occupants or other persons. Moreover, Section 27 of the Act restricts who can be present at a meeting, which is a hearing, and also at certain meetings dealing with private matters. So the bottom line is, if you're going to be dealing with having these meetings, then if it's a bylaw contravention hearing, or if it's a rental restriction meeting, or if the presence of observers would, in council's opinion, unduly interfere with an individual's privacy, or if there is an in-camera meeting dealing with a sensitive issue, or if it's litigation privileged, then those are the situations where no observers should be present during those meetings. And I don't see any problem whatsoever in drafting a bylaw that confirms those types of restrictions. So it's really open to a strata corporation at a council meeting through its bylaws to make a determination regarding the scope of observers' presence. So who can be present? Is it going to be anyone can be present at any time except for these matters that are governed by the legislation where you can't be present, hearings, for example? Or do you want to restrict it to no observers can be present? And this is really, there's a certain level of discretion regarding the scope of observers, and you can deal with that as part of your bylaw amendment procedure.
So the next question, there's a whole group of them together that go to the same topic, so maybe we'll kind of walk through it. There is, if you have a hearing and that is all that's on the agenda, what would the minutes include with respect to that council meeting? And so in that, would you include the response, the written response that was sent to the owner? Do the owners need to be notified of the outcome of hearings? And are the decisions necessary if you have an electronic meeting? Do you have to respond to that decision in writing? Could it be verbal to the applicant? They have to obviously be in a written format. But again, this also goes back to the other problem that is arising, where council members in hearings are taking notes, and they're creating a record of the information of what occurred in the hearing. You know, it creates a dangerous problem for strata councils when they do that. It's an opportunity to gather information to be able to formulate a response. But there are times when strata councils do need to gather specific information or records and documents relating to financial or medical matters as they're making a decision. So, you know, I guess the sensitivity is what goes in the minutes, what information does a strata council really have to retain or access?
So the question relates to how does a council, once a decision has been made, deal with that decision? How is it recorded in the minutes, and what information is actually recorded in the minutes, and who is that decision provided to? So the answer is going to be a very short one. The only thing that council needs to record in the minutes is anything that is a decision of the council. Now, clearly it can record that a hearing has been held at the request of strata lot X, but if there is no request for a decision from the applicant, and that would be in the written request from the applicant, then there is no necessity for a decision. So the only thing that needs to be recorded, and there's no requirement, a legal requirement for this as well, is that the hearing was in fact held. Now, if there is a request for a hearing, then the decision of the council needs to be recorded in the minutes. So that means that if the council approved the request for the hardship application, then the minutes would reflect hardship application granted strata lot 10 and whether there's any conditions. Now, there's confidential information that was addressed during that hearing regarding financial information. It could have been other information as well. There isn't any need, and in fact, you shouldn't be making reference to that information or attaching it to the minutes. It can be kept separately by the strata manager, but it should not form part of the minutes of that meeting. The deliberation on the decision and what needs to be recorded in the minutes is something that should be determined with legal counsel for the strata corporation. It may be that the strata corporation wishes to look reasonable and that it wants to, for purposes of a tribunal hearing or a Supreme Court hearing, ensure that the items that were addressed by the council tick off certain boxes. So in that event, it's possible that the decision leading up, or the factors leading up to the decision could be recorded in the minutes. But the bottom line is keep the minutes clean. Aside from legal advice on any other matters that go into it, it's just what is the decision? Was it approved or was it not approved? Are there any conditions? And that's the end of it. Any confidential information should not be included. Minutes should not be available as part of that hearing process. The notes from council members shouldn't be distributed. That's not the purpose of the hearing. So that information, if it's to be kept, should be kept separately, sealed with the lawyer or sealed with the strata manager in a secure location if there's court proceedings. But outside of that, the only decision should be, was the matter approved, yes or no, recorded in the minutes, and distributed to the owners in the ordinary course. These are difficult questions.
They're good questions, yeah.
Very good questions. They're very difficult questions. And frequently a quick answer is not, we're not able to give one because it's too complex.
Well, and I think that's the difficulty that a lot of strata councils struggle with, is they may have unique circumstances.
Yeah.
That really not every bylaw is going to resolve for them, right? It's the opportunity to accommodate their members as much as possible to accommodate all of their voting rights wherever possible. And it actually does lead into another question, and I think this will become more evident to strata corporations and managers as we go along. If a strata corporation deems or elects to have an annual or special general meeting by electronic means, and they have someone who cannot attend electronically, do they have to accommodate them otherwise? And the answer is no. An electronic meeting is permitted, and it's the format that's being published, and if they can't attend, then they have the opportunity to issue a proxy, and stratas are accommodating them by issuing, allowing for a restricted proxy to be included, so that their voting wishes have to be respected. But the strata, it would be no different than saying, as opposed to having our meeting on site, we're going to have our meeting at the Best Western 4 blocks away, and an owner says, well, I can't get there. Again, we can't accommodate that. You know, we've given you a location and time and a date. If you can't participate in the meeting, you have the option of issuing a proxy.
Yes, and just in furtherance to that, right now there is an order for electronic general meetings, and so during the emergency circumstances, that order will trump any other practice or procedure. So during that particular order, there's absolutely no question you can proceed with electronic meetings. If there's any doubt in a strata corporation, or if this becomes an issue in your strata corporation, it's a good idea to look at amending the bylaws to make it abundantly clear that electronic meetings will be held electronically. And although there could be people that cannot attend, that is the procedure. And so I would encourage people to be, from the council level, transparent with the owners and advise them that they're still at liberty to provide a proxy, so they're not denied the right to vote. But there are other methods available to deal with the matter. But at the end of the day, Tony, you're 100% correct. Electronic general meeting called electronically must be held electronically. And because someone cannot attend at that meeting doesn't mean that it will affect the validity of that meeting or the constitution of that meeting from a legal perspective.
Yeah, and tying into that, I think the other challenge that we face is, part of it is the terminology. I think strata corporations and managers are referring to electronic meetings as restricted proxy meetings. There's no such thing, and everybody has to get over this. A restricted proxy is for the privilege and benefit and convenience of owners. It is not something that the corporation can impose. You have two options. At this point right now, you either hold a meeting in person where everybody can attend, which is almost impossible given the social distancing requirements, or you hold a meeting electronically. You have to physically hold the meeting, because if you don't hold the meeting, none of those proxies are valid. They have to be registered and they have to be certified, and the person representing those proxies has to execute those votes. So if you hold a meeting electronically, then your eligible owners are also entitled to attend that meeting electronically, and they can vote and ask questions. And and for whether it's a large or a small strata, it still works quite well. And we've seen very large strata corporations, over 400 units, that have actually held electronic meetings, allowed owners for their convenience to submit a restricted proxy, and they had less than 20 people attend the electronic meeting in addition. It was very manageable. And at the time of voting on the resolutions, for the 20 people who attended, it was just a poll. They were just asked, how do you vote on these resolutions? And their voting results were recorded in the minutes. So it still has to be a meeting. It still has to, it's not, an electronic meeting is still a fully convened meeting. And people have to attend it electronically if that's an option.
Correct. And we do recommend, and you and I have spent several weeks working out bylaws for this purpose, that when you're holding an electronic general meeting, that you need to lay out the different protocol and procedures for this electronic general meeting. And you will be making a number of amendments to the agenda for the meeting. You don't certify proxies, you deal with proxies in a different way because you're dealing with the meeting electronically. So there's a number of amendments that need to be made to electronic general meetings. But going back to your point on restricted proxies versus proxies in general, they're still proxies.
Exactly.
And so there's no such thing as a restricted proxy for a specific meeting. So caution should be exercised there.
Well, the restricted definition of the proxy, restricted or limited, are conditions that are imposed by the owner.
Correct.
Right? And
Yes.
for courtesy and convenience, strata corporations are sending them out that way to owners to guarantee that their voting instructions are upheld, which is
Correct.
the best way to accommodate owners.
Yes.
But it falls also into the next part, which is I think an issue coming up with respects to the election of council is that, you know, the owners want to know how can we vote by secret ballot at electronic meetings? You can't. It's not possible to conduct secret ballots because there's no way of verifying who has executed the ballot, and there's no way to audit whether those are valid votes or not if you have secret ballots. So it isn't possible to do that. The strata doesn't publish how each person voted in the minutes. They just publish the voting outcomes. And so, you know, and that's I think, again, that is the result. But at this time more than ever, it's important that they report accurate voting outcomes with respects to the total number of who voted for, against, or abstained, to show that they actually had the physical numbers, the quorum existed, they calculated the votes correctly. All of this provides very good supporting evidence in the event that there was ever a challenge to the CRT.
Absolutely, and going back to the secret ballot vote and electronic general meetings, it's recommended that the bylaws indicate and clarify that secret ballots will not be permitted at or cannot be held at an electronic meeting. And so the bylaws could clarify that issue, and then it'd be taken right off the table.
Yes, yeah, that would be the best solution. One last question, and then we're going to round off. I think we've captured the lion's share of all the questions. And thank you to everyone today who attended. Last question is, people want to know where they can get a copy of the book. And they can either contact Donna at the CHOA office, and she'd be happy to set that up for them, or you can contact Cora's office. In addition, Cora has written a paper on this whole subject of council meetings and hearings. We're going to post the paper along with the YouTube video tomorrow, and there will be there's order information on that, that you'll be able to identify a location of where to order the book at the same time. So thank you everyone today for participating. Again, if you have any questions at all, please email us. Thanks to Power Strata Systems in North Vancouver, who are an online digital host for websites for strata corporations, which we strongly encourage because strata corporations have a very difficult time maintaining corporate history and corporate memory. And so if there is some way you can create a website for your strata to load all of your digital documents, to load all of the content and material that's on there, it's a great resource and access for your property managers and for your strata councils. So something to think about. And then one last note, next week we're adjusting the schedule, and we're doing a special session just to deal with how people are implementing and accommodating the use of their common areas, recreation facilities, meeting rooms, public spaces, and providing access to strata lots for maintenance, repairs, and inspections as we start to implement phase 2 of social distancing and the emergency orders in BC. So I expect there'll be a lot of participants for that and a lot of questions relating to that. But the health boards and the province and WorkSafe have provided some phenomenal resources that we'll be able to share, and if you haven't already seen them. Anyhow, thank you so much. Thanks, Cora, again for a great session, and we'll look forward to seeing everybody again in the future.